Welcome to this 42 Bedford Row Barristers webinar on rent repayment orders. My name is Mathew McDermott. I'm a specialist property barrister here at 42 Bedford Row, and I'm one of the two speakers for today's webinar. I'll be dealing with the second part of the webinar, with the first part being dealt with by Rob Winspear, also a barrister here at 42 Bedford Row, whose work also spans the broad spectrum of landlord and tenant disputes. Before I hand over to Rob, I'll just briefly make two observations that will be relevant to the general outline of this webinar. The first is that the webinar focuses primarily on the quantum of rent repayment orders, that is, the amount of rent repayment orders. Whilst Rob touches upon rent repayment orders in their sort of broader statutory framework, the focus on this webinar is not on the liability, that is, what it is that takes a landlord to be found responsible for a rent repayment order, but instead it focuses on the amount, the quantum of that rent repayment order. And then the second point to bear in mind is that whilst both tenants and also local housing authorities can apply for rent repayment orders, that they can be the recipients of rent repayment orders. Again, this webinar is focused more at the former, that is more at the tenant or the tenants who are making the application. Although broadly speaking, much of what we say would also apply to a local housing authority who's seeking repayment of universal credit. But the essence of it is to focus on the tenant or the tenants who are reclaiming the rent. So with those 2 points in mind, I shall hand over to Robert.
Thanks, Matthew. I want to begin this webinar with a very, somewhat brief overview of the statutory regime, so that it frames the rest of the talk and provides some context when Matthew and I begin to discuss some of the recent cases in this area. Fortunately for us, there isn't a lot of statute to go through. As you can see from the slide that we're looking at, really all we're dealing with for the purposes of this talk is the Housing and Planning Act 2016. So for the rest of the webinar, I'm just going to refer to it as the Act. Starting with what offences can attract a rent repayment order, you can see on the slide which ones there are. This is a table from section 43, subsection 3 of the Act. And although Matthew and I are going to focus on the licensing offences, which can be seen at row 5 and 6, as they are overwhelmingly the most common basis for seeking a rent repayment order, the other offences are relevant to the licensing offences themselves. The reason why they are relevant is because of their relative seriousness as compared to committing a licensing offence. So, for example, as you can see in rows 1 and 2, violent entry of a property or unlawful eviction are clearly more serious offences to be committing than the offence of failing to obtain an HMO or other licence that's needed for a rented property. This comparison between all of the offences in this table is something that the tribunal focuses on when determining what the quantum should be in any given rent repayment order case. I'll say no more than that at this stage because Matthew, in his part of the webinar, is going to explain the effect of this comparison exercise on quantum when he discusses some of the recent cases. So looking at section 41(2) now of the Act, assuming for our purposes that a licensing offence has been committed, so in other words, a landlord's knowingly or unknowingly failed to license his or her property, section 41(2) then sets out the ability of a tenant to apply for a rent repayment order. And as you can see on the slide, a tenant may only apply if the offence relates to housing that at the time of the offence was let to the tenant So that's fairly straightforward, but obviously it means that a non-tenant cannot obtain a rent repayment order, and neither can a tenant apply for a rent repayment order for any period after the tenancy has ended. And limb B of section 41 subsection 2 introduces a long stop date. So it requires that any application must be made within 12 months from the last day of the offence. So in my opinion, that's a fairly generous long stop. In theory, it means that a tenancy could end, and then 11 months later, when the tenant's in completely new accommodation, completely unrelated to the property that concerns the licensing offence, they would still be entitled to bring a claim 11 months after they stopped living in that property. So looking at section 44.2 now, provided the tenant meets the qualifying conditions in section 41.2 that we've just discussed, and provided the tribunal is satisfied beyond reasonable doubt that an offence has indeed been committed, one of the ones in the table that we first looked at, the tribunal then has to go on to determine the amount of the rent repayment order by reference to this section, section 44. And really, it's the interpretation of this section which has generated a fair amount of decisions on appeal in the upper tribunal and in the Court of Appeal in relation to its meaning and effect. So starting with section 44.2, this subsection, as I see it, is geared towards figuring out what the maximum rent repayment order, in theory, could be. On its face, section 44.2 says that the amount, and it's referring to the rent repayment order, must relate to rent paid during the period mentioned in the table. And you can see the table underneath the actual wording that follows subsection 2 underneath. So you might think that you then look at the period relating to licensing offences, which is in the second row of that table, and it says a period not exceeding 12 months, something that I'm going to call the liability period, during which the landlord was committing the offence. So you might think, simple as that. You look at the liability period, which can be up to 12 months. You then look at what the rent was paid, what rent was paid in that period, and that is your maximum for the purpose of this inquiry. However, what this table also includes is a heading that you can see in bold. Now that introduces a similar but slightly different phrase, which states that the amount must relate to rent paid. So you might think, simple as that. You look at the liability period, which can be up to 12 months. You then look at what the rent was paid, what rent was paid in that period, and that is your maximum for the purpose of this inquiry. However, what this table also includes is a heading that you can see in bold. Now that introduces a similar but slightly different phrase, which states that the amount must relate to rent paid outside of the liability period, can be included in this calculation, provided that it is paid in respect of a rental liability that fell due during the liability period. So in other words, if a tenant was obliged to pay rent in month 11 out of the 12-month liability period, but in fact paid that liability in month 13, which was outside of the 12-month liability period, can that payment, which a tenant may argue was paid in respect of month 11, and so in the liability period, be included in the calculation? I'll leave that question there, and I want to come back to it in the next slide when I discuss the authority of Kawalec and Hassanine. But once you've figured out the potential maximum rent repayment order, so what is the total amount of rent that's been paid in the liability period, section 44.3 goes on to say that the amount ordered must not exceed that maximum, and then you subtract any award of universal credit that was paid in respect of rent. Section 44.4 then goes on to say that in determining what the actual amount should be, rather than the maximum, the tribunal must, in particular, take account of the following things. And those are the conduct of the landlord and tenant, the financial circumstances of the landlord, and whether the landlord has been convicted of an offence to which this chapter applies. So in other words, is the landlord a repeat offender? From the words in particular, that confirms that these are not the only factors that must be considered. The tribunal is entitled to take into account anything that is relevant to the offence. So that's the statutory scheme. What I now wish to do is discuss two cases which consider the meaning and effect of, in particular, Section 44, before handing over to Mathew, who will explain the most recent way to calculate quantum in rent repayment orders. So starting with Kawalec and Hassanine that I mentioned just before. This is the Court of Appeal case that Mathew and I appeared in. I was Mathew's junior, and we were representing the respondent, Hassanine Limited. In a nutshell, this appeal was all about what the maximum possible rent repayment order ought to be. So looking at the table in particular, more so than the Section 44.4 factors. They do come into it, but I'll explain what I mean now. First of all, I'll just explain what the facts of the case are to provide that context. So Hassanine Limited was the landlord of a luxury new build flat that was worth about £1 million. It granted an assured short hold tenancy to Mr. and Mrs. Kawalec, who paid 3 months' rent in advance. The rent was about £3,500 a month, so it was a high value rental property. At some point during the 24-month tenancy that was agreed, Mr. and Mrs. Kawalec stopped paying their rent, and substantial arrears accrued. Hassanine Limited brought possession proceedings, but before those proceedings reached the county court, Mr. and Mrs. Kawalec applied for a rent repayment order. That was done on the 10th of January 2020 and sought repayment of approximately £23,000, the total amount of rent that was paid during the currency of the tenancy. Hassanine Limited was totally unaware that it needed a licence, and so it was guilty of managing an unlicensed property. It was in fact Mr. Kawalec's application on the 10th of January that put Hassanine Limited on notice of their offence, and so shortly afterwards it made its application for the appropriate licence, and that was done on the 27th of January 2020. That date's important because then one day afterwards, on the 28th of January, Mr. Kawalec made a payment of £2,000 to the company. Mr. Kawalec then sought to increase the amount claimed in his application by that amount. So instead of seeking £23,000 odd, he then sought to recover £25,000. And that was the basis of the claim. So when the claim reached the FTT's decision was that Hassanine Limited was guilty of the offence. It didn't matter that it was an unintentional failure to license the property. They were guilty. That was the end of the story. But what the FTT decided to do is, first of all, it declined to include that £2,000 that Mr. Kawalec sought to increase his application by, on the basis that it was paid after the offence had stopped being committed. And secondly, the FTT decided to reduce the amount claimed by Mr. Kawalec by 50%, and that was to take into account the substantial arrears that Mr. Kawalec had allowed to accrue during the tenancy. That decision was appealed in the upper tribunal on two bases. The first, and why I spent some time on the last slide looking at the specific language of Section 44.2, is that Mr. Kawalec argued that the £2,000 paid one day after the offence had stopped being committed on the 28th of January ought to be included in the calculation because it was paid in respect of rent that did fall within the liability period. That was the first argument. The second was that the existence of rent arrears, which the FTT used as its basis for a 50% reduction, ought not to be considered relevant tenant conduct under section 44.4, the argument went that because rent was not paid during the liability period, the tenant was already punished by that failure because the maximum rent paid during that period is reduced. So in other words, to take some easy numbers, if in the 12-month liability period, the rent was £10,000 and the tenant only paid £5,000 during that period, then the maximum under section 44.2 that the FTT could determine is only £5,000 rather than £10,000, which was the maximum of the rental liability. And so Mr. Kawalec argued that the amount shouldn't be reduced any further from that reduction because the tenants already suffered that reduction by virtue of not paying their rent in the liability period. Those arguments did not succeed in the upper tribunal, but permission was given to appeal to the Court of Appeal, and those same two questions were considered by the Court of Appeal. Ultimately, the Court of Appeal also rejected those arguments. Lord Justice Newey, giving the lead judgment, focused on the lack of meaning that the wording above the table in section 44.2 would have if the appellant's argument regarding the £2,000 was correct. He also took account of the purpose of the legislation and noted that its intention was to deter rogue landlords. Its intention was not to reward or provide a windfall to tenants. And so ultimately he agreed with the observations of Martin Rogers in the upper tribunal, who said that it was no surprise that a landlord ought not to have to repay rent during a period where the offence was no longer being committed. So that's the answer to interpreting the table in section 44.2. For rent to come within this initial calculation of what the maximum is, the money has to be paid both within that 12-month liability period, and secondly, the money must also relate to a rental liability that arose within that liability period. So in a sense, it's a two-stage test. Regarding the second ground of appeal, which was whether rent arrears can be considered relevant tenant conduct, again, this ground was also dismissed. Lord Justice Newey, in particular, relied on another authority of Regal Grand and Dickerson and Wade. In that case, it considered the meaning of conduct as meaning behaviour, and it held that a failure to pay rent in a slightly different context, but nevertheless is behaviour and so must be seen as relevant tenant conduct. Lord Justice Newey also drew from Judge Elizabeth Cook's observations in Awad and Hooley, which is a case that Mathew will be discussing, where she commented that it would offend any sense of justice for a tenant to be in persistent arrears over an extended period and then to choose a particular period where she did make some regular payments and then be rewarded and awarded repayment of all of what she paid. So in a sense, that was the end of that. The decision was that rent arrears are indeed relevant tenant conduct. There isn't any element of double counting that Mr. Kawalec would wish for the court to accept. And as a result, it is likely that if there are any rent arrears relevant on the facts of a rent repayment order case, that is going to result in a reduction of the award when considering the section 44.4 factors. So that's Kawalec. Now, lastly, I just want to touch on another case called Vada, Malayan, which is just on the next slide. Vada, Malayan is an upper tribunal authority from 2020. And it's an interesting decision for a few reasons, but in particular because it set the FTT off in a certain direction that more recently has been moved away from. It decided, in summary, three things, two of which are still followed. The third is the one that's been moved away from. First of all, Vada, Malayan looked at the older regime that gave the FTT authority to make rent repayment orders. And it noticed that some language was missing in the new act, the Housing and Planning Act 2016. Under the old regime, there was an element of reasonableness as to what order the FTT should make as against a landlord. And the way the authorities went, it was Parker and Waller. it decided that therefore only the profit element of what a landlord receives from a tenant after mortgage expenses and other expenses incurred in maintaining the property should be the amount that be repaid to the tenant. What Judge Cook noted in this case is that because there was no reasonableness threshold under the Housing and Planning Act 2016, and really the only reference was to rent, there was no explicit reference to profit, therefore any rent repayment order has to relate to all rent paid during the liability period following the language of section 44.4, well, section 44 generally, rather than just the profit element. What she held or observed is that payment of any mortgage or payments spent on keeping the house in repair enrich the landlord in some sense. So it's not right for the landlord to be able to keep hold of those costs or have to not repay them to the tenant if they are guilty of an offence. And that decision continues to be followed. That's something that has to be borne in mind. It's all about rent nowadays. It's not about profit. That's not an exercise that should be followed. The next thing that was held is that despite that decision, what she decided is that the possibility of utilities being wrapped up in a rental payment is something that can be deducted from the maximum of a rent repayment order. What she held is things like electricity and gas are only benefiting the tenant. They don't enhance the landlord's own property in any way. And so therefore it'd be unfair for a tenant paying a rent that included utility costs to get more by way of a rent repayment order than another tenant whose rent did not include utilities. And as I say, that's another aspect of this decision that continues to be followed. However, it's the third aspect that's been moved away from. And what happened is Judge Cook looked at the wording of section 44.4 and decided that it required the FTT to find as a starting point, sorry, it's 44.2, but she thought that it required the FTT to find as a starting point what 100% of the rent in the liability period should be before then moving on to the section 44 factors to decide if there should be any reduction. And it's this aspect of Judge Cook's decision in Vada Malayan that the upper tribunal in more recent decisions has moved away from. But I'll now hand over to Mathew to explain what direction the tribunal's taken and to explain the current method of calculating quantum in these sorts of cases.
Thank you, Rob. Yeah, I'll just pick up on that last bit regarding Vada Malayan. Effectively, the upper tribunal in the cases that followed just wanted to ensure that there wasn't a misunderstanding or confusion arising from the use of that phrase starting point, which is why that part of the presentation ends with a but and leads on to the next slide. Starting point in itself is correct, but a handful of cases, all in the upper tribunal, all 2021, just made it clear, just to avoid any confusion, that there wasn't a presumption that the amount of the rent repayment order should, as a starting point, be 100% of the rent that was paid in the relevant period. Effectively, that is the position after the cases that I've listed there: Ficarra and James, Awad and Hewley, and Williams and Palmer. So effectively just seeking to clarify the use of that particular phrase and making it clear that there is no presumption. What I'll do now is I shall turn to one other case of the upper tribunal and seek to flesh out the sorts of things that might increase the amount of a rent repayment order, might aggravate it, but at the same time might lead to it going down, decrease, mitigating factors. So the starting point here is the case of Akiampong and Roman, 2022, again the upper tribunal, and again a decision of Judge Elizabeth Cook. A good part here to read out first before we go to the 4 stages is this. There are no rules as to the amount to be repaid. There is no rate card. But it is safe to say that if the landlord is ordered to repay the whole of the rent after deduction of any payments for utilities, which is what Rob's touched upon, without consideration of the seriousness of the offence, or in a case that is far from the most serious of its kind, it is likely that something has gone wrong and that the FTT has failed to take into consideration a relevant factor. So that's a nice introduction to what the FTT is likely to see as the following 4-stage approach to the quantification of rent repayment orders. So the 4 steps, and I'll go into each one in a little bit more detail, are firstly, work out 100% of the rent in the relevant period, which Rob's already gone into. Subtract any utilities or other costs that are only for the benefit of the tenant or tenants. Consider the seriousness of the offence, and that is the seriousness of the offence against the other prescribed offences, those listed offences that Rob explained at the beginning, but also offences within the same category. And then 4th and finally, consider whether the amount should be increased or decreased in light of the other factors that are in subsection 4 of section 44. So to turn then to the first one, which is, or will be in most cases, the easiest, ascertain the whole of the rent for the relevant period. It should be straightforward, and before I turn to step 2, it's just worth highlighting something that was said in that case of Kawalec. The maximum amount of a rent repayment order must be determined without regard to rent, which, while it might have discharged indebtedness which arose during the period specified in section 44, subsection 2, was not paid in that period, which is a point that Rob's already addressed, the essence of it being focus on the date when the rent was paid. That's step 1. You're effectively trying to establish the boundaries, the outer limit, the maximum. And then, once that is done, you move to step 2. This is probably going to be a matter for evidence, which is you would subtract any element of that sum, step 1 sum, that represents payments for utilities that only benefited the tenant. And Rob's touched upon this. Gas, electricity, maybe broadband. The first tier tribunal, the FTT, is a specialist tribunal. So if there isn't expert evidence on what the broadband bill was or what the gas may have been, then it might be open to the FTT to use its expertise and come up with figures that are reasonable for the broadband, for the electricity, for the gas, whatever the utility may be. But preferably, especially from the landlord's point of view, it would be the case that the landlord advances evidence, provides the bills, provides the broadband information for whatever it might be. So that if there are utilities provided exclusively for the use of the tenants, the FTT will know what the figures are, and if the occasion arises, can deduct that from the stage 1 or step 1 figure. So that's step 2, which then leads us on to step 3, which is where far more of an element of discretion comes into it. Consider how serious this offence was, both compared to the other types of offence in respect of which a rent repayment order may be made, and whose relative seriousness can be seen from the relevant maximum sentences on conviction, and also compared to the other examples of the same type of offence. What proportion of the rent, after deduction as above, which is effectively the step 2 deduction if it applies, what proportion of the rent is a fair reflection of the seriousness of this offence? And then that figure is then the starting point, in the sense that that term is used in criminal sentencing. It is the default penalty in the absence of any other factors, but it may be higher or lower in light of the final step. So before turning to step 4, the next part just goes into that in a little bit more detail. So 2 comparisons, really. It's comparisons of the offence that is present in your case, in the present case, if you like, as against the others, the other categories of offences that can lead to a rent repayment order. And as Rob was saying, it may well be the case, in fact, it's probably going to be the case in most situations, that a licensing offence, a failure to have a licence for a HMO, for example, isn't going to be as serious as some of the other offences that you see in that table, like using violence to secure entry into residential property or harassing the occupiers. So that's, if you like, part 1 of step 3. Compare it to the other types. But then comparing it to the, compare it to the different types of offences of that kind. So what I mean by that is there will be a whole spectrum of severity. Licensing offences are quite a good example of that. You can have a trivial, unimportant breach, but still technically a breach, all the way through to quite a severe, hazardous, important regulatory breach. So the point is, you've got to assess, or the FTT, I should say, is to assess where on that spectrum, where on that scale, this particular offence happens to lie. And as I say, that's going to involve much more of a question of discretion, which is important because if anybody is upset, if a landlord wishes to appeal or a tenant wishes to appeal, questions of discretion are always notoriously difficult to appeal. Being able to convince an upper tribunal judge that the first tier tribunal exercised its discretion wrongly is quite a difficult hill to climb. So we've got, in this scenario, our maximum, that's step 1. We've considered whether or not there are any exclusive utility benefits to be deducted, that's step 2. And then we've also now undertaken this comparative assessment of the offence that we are dealing with in our fictional case, if you like, that's step 3, which brings us on then to the final step from this decision of Judge Elizabeth Cook in Akampong. Consider whether any deduction from or addition to that figure should be made in the light of the other factors set out in section 44, subsection 4. Rob's already displayed them, but I've just listed them again here for ease of reference. So those other factors will be the conduct of the landlord and the tenant, the financial circumstances of the landlord, and whether the landlord has at any time been convicted of an offence to which this chapter applies. So effectively at step 4, it's a matter of considering for the FTT whether the figure goes up or whether the figure goes down, considering those listed factors. As a 2022 decision, now what I will do is try to illustrate some of the cases that have given us examples of how rent repayment orders tend to be assessed, what tends to increase them, what tends to decrease them. So the first case is a 2021 case, so predates Akampong. It's also worth highlighting that this is an exception to the general rule of our training, of our webinar today, which is this is not a tenant application, in that it was an application that was made by the Metropolitan Borough Council seeking a rent repayment order for the universal credit that had been paid in respect of the occupation due to a failure to license the HMO. The other important thing to distinguish it from much of what Rob and I are talking about is that the landlord in that case had been convicted of an offence in the magistrate's court. Now that's important because that invokes section 46, which we've not touched upon. It's not really central to the essence of this webinar, but it is important because due to the conviction, effectively section 46 says in summary, that save exceptional circumstances, the maximum would be payable. In other words, that those three bullet points in subsection 4, the section 44 that I've just had up, are not part of the process in these cases. And that's quite important, because in this case, actually, some submissions were made on appeal that showed that the costs of running the HMO in question actually resulted in a loss, which was advanced as an argument. It might be felt quite a persuasive argument to say that the amount should be less. The FTT did not agree with that, and the upper tribunal, to come back to my point really about interfering with decisions of the first tier tribunal, did not consider that that was an error to not reduce it from the maximum as a result of, or in light of, the fact that the running costs actually led to a loss. That was not an error of law. It might have been that the upper tribunal judge would have considered it differently, or maybe a different first tier tribunal would have considered it differently, but it was not wrong, and the upper tribunal didn't interfere with it. So that's the local housing authority case of Ball and Sefton. So moving on, and now into 2022, Hancher and David, again, all the cases that I'm discussing are upper tribunal cases, and again, this is a case where the offence in question, the listed offence, was being in control of an unlicensed HMO. It was said that it was not one of the most serious examples of offences that can lead to a rent repayment order. And again, that's a reference to some of the other categories that you saw on that list. It was likely that had a licence been sought, it would have been given, meaning that the requirements were met. But at the same time, the breach was deliberate. And so even though the condition of the property was such that a licence probably would have been given had it been sought, 65% of the relevant rent was awarded. The next case is Hallett and Parker, which again is a failure to license an HMO case. Effectively, that's the basis, that was the basis of the tenant's application for the rent repayment order. But it was said that the property was in fairly good condition and that the landlord was not a professional landlord. So a couple of factors there: condition of the property, status, degree of professionalism of the landlord. It was also said that it was the first time that the landlord had let to a group of tenants that had not formed a single household, that being important because it was that fact, that new letting, that actually resulted in the requirement for the license. And it was also relevant that there was a letting agent that had not alerted the landlord to the need for a license. And finally, if you like to add to this relatively long list of mitigating factors, the license was promptly applied for once the landlord became aware of the need. And the upper tribunal set aside, as is often the case in the decisions that I'm talking about, set aside the first tier tribunal's decision and imposed a rent repayment order of 25%, or if you like, a reduction of 75%. But before moving on, it is useful to note that one of the things that was mentioned was that following a submission that was made on behalf of the landlord, just because the local authority hadn't prosecuted, so again, going back to that Bull case where there had been a conviction, but just because in any given case there wasn't a prosecution, that shouldn't really be interpreted as some sort of mitigating factor, some sort of factor that works to the credit of the landlord. There might be myriad reasons as to why no prosecution has been brought. The next case is a joint appeal, in the sense that the upper tribunal was dealing with two separate appeals, Ayton and others, and Moore and others. The first of these appeals, they're both actually unlicensed HMOs case, but turning to the first, HMO required a license. There wasn't a license. In a way, not dissimilar to the previous case, the landlord's reliance upon the use of an agent. This was wrestled with in a fair amount of detail, and it was said that it would rarely give rise to a reasonable excuse so as to amount to a defence. Now, just to go into that in a little bit more detail, obviously we're dealing primarily with the question of quantum, but a reasonable excuse is something that provides a defence to the entirety of the application, in the sense that if you have one, there will not be the conditions met for a rent repayment order. But what was said here is that effectively having an agent would rarely provide one with a reasonable excuse so as to be able to avoid liability for the order itself. But coming back to the facts, in this particular case, the landlords owned multiple properties. So again, that's a reference to the professionalism factor, if you like. You've got on one end of the spectrum the landlord who lets maybe just one property, their first-time landlord, all the way to the other end of the spectrum. And this factor is one of those in terms of where it falls on the spectrum. So in this case, there were multiple properties, that is whether in their own right or just simply through limited companies that were owned. That was seen as an aggravating factor. In other words, a factor that counted against the landlords and in favour of the tenants. And as a result, substantial order was made following set aside of the original decision of 85%. That is a 15% reduction. So another example of another substantial rent repayment order. So turning then to their second appeal in this conjoined appeal. Again, as I've said, another unlicensed HMO offence. A licence had been sought, and in other cases, as I've shown, the degree to which one promptly applies after one finds out a licence is needed has been seen to be a relevant factor. And in this case, a licence was sought, but the property wasn't eligible. In other words, it wasn't licensable at the time because it lacked fire alarms and fire doors. Those alarms and doors fitted eventually, but a year after the application for the licence was made. The landlord was said to be a professional landlord on a small scale, the property in question having once been the landlord's home. But, and really this is the key point, the defects, that is the absence of the fire doors, the absence of or the lack of the fire alarms, that was serious. It was very serious, and that resulted in just a 10% reduction, or in other words, a rent repayment order reflecting 90% of the rent. So, as can be seen there, to really conclude factors, the only case so far, purely on the question of quantum, that's reached the Court of Appeal is the Kawalec case that Rob's discussed. All the other cases that I've been discussing are in the upper tribunal. But clearly there is now a focus on certain factors like the professionalism of the landlord. Are they to the amateur's end all the way through to the very professional end? To what degree is an agent involved and how reasonable is it to rely upon that agent? What was the condition of the property if it was a licensing offence? These are a number of factors that are likely to be present in most cases and therefore likely to be of importance when it comes to the assessment of the rent repayment order. So I hope that, well, on behalf of Rob and we hope that the webinar there has been interesting, informative. Much of this change these changes have happened in the last 18 or so months. You will have seen that most of the cases that I talked about were 2022 cases, with a couple of 2021, which is inevitable with this law being relatively new. So one can only wait to see what happens in the future. And as I say, if any case reaches the Court of Appeal. But thank you for watching. If there are any questions, you can see our contact details there. And we do hope that you have found this informative. Thank you.